Mr. Shekato.
Good morning, Your Honors. I represent Damian Clemente, the son. My co-counsel represents the father, Anthony Clemente. I moved to join her brief on the motion for new trial issues. I thought I would have a ruling on it before actual oral argument, but I don't. So I want to say again that I've moved to join that. The way we've divided the argument is I'm going to deal with the issues in my brief, and Ms. Capiccio is going to deal with the motion for new trial issues. In this case, in closing argument for Damian Clemente, the son, defense counsel argued at volume 19, pages 123 to 125, that he didn't argue self-defense. He argued defense of his father and sudden combat, heat of passion, the emotion being fear. This was the defendant's theory in closing argument. We had a very, now retired, but a very conservative trial judge who chose to charge the jury, and by conservative I mean pro-Commonwealth. Maybe everyone doesn't see that as conservative, but I do, who chose to charge the jury on manslaughter and defense of another and self-defense. The Commonwealth concedes in its brief that there was an Acevedo error in this case. In other words, that the
But why was the defendant entitled to a provocation instruction anyway? We've often held that words, no matter how bad they are enough.
Yes, and of course there are exceptions to that rule too. If the words are about your wife being in bed with somebody else.
But that doesn't apply here.
Well, I think the general principle does apply, that while words generally are not enough, what really is at issue is whether or not a reasonable person would consider what happened to be sufficient provocation.
Is that the rule?
I believe it is, Your Honor.
So and you're saying that here, the words "nobody's getting out of here alive," the reputation of the guy, and the fact that he made a hand gesture towards his fanny pack might have suggested that there was a weapon in there, and that
I think any reasonable person, given who these people were, would have believed that he was reaching for a weapon. And given what happened at the scene afterwards and what happened to the fanny pack and the fact that there was a sixth person that we now know about that was there.
Well, the fanny pack, you allude to that, and I know that that's not one of your arguments, but even if there were gun residue on the fanny pack, what would that show?
Oh, well.
I mean, because you were saying with the fanny pack.
Well, I think that on the evidence in this case, one could conclude that others had access to that fanny pack before the police looked at it, and that there may very well have been a gun in the fanny pack.
Well, whether there was a gun or not, I take it is not important to your argument.
I agree, Your Honor. I don't think it really matters whether there was a gun in there or not. What matters is whether or not there was reasonable provocation, whether a reasonable, ordinary person, knowing what Damian Clemente knew at that moment in time, would have been.
I have a problem with this. I understand how that's very much relevant to self-defense, the reasonable apprehension of an armed assault. Based on both the movements and the reputation of the individuals involved. But I really don't see, we've generally held that if someone goes to a meeting armed for purposes of a confrontation, the provocation defense really doesn't apply.
Well, that's true generally, but they didn't go to this meeting armed for purposes of a confrontation. The evidence
Certainly Anthony did. I thought that was the evidence. He got a call from his son saying at a restaurant, these guys are here. I'm scared, and so he got his gun and went down and confronted them. I know that's not your client. Right,
but it's not what even the weight of the evidence is. It's what the evidence is in the light most favorable to the defendant. And in the light most favorable to the defendant, Anthony Clemente said that he didn't go down there to confront them. He went down there to make sure that his kids got out of there alive.
It might take his kids getting out of there alive might take killing the people who were preventing them getting up.
It might, but that wasn't necessarily his intent. And
but is he disqualified from provocation in circumstances where he could reasonably have called the police for assistance?
No. Provocation is not a defense. In other words, it doesn't say I'm innocent, because it says that in recognition of the frailty of human nature, we say that in certain circumstances, people who have committed a serious crime, manslaughter, you can get up to 20 years for it, even though they've committed a serious crime, it's not murder, because we understand that a person may be acting under a strong emotion that they couldn't control.
How is it provocation when he goes there armed and I mean, talk about ability to retreat or anything like that? I mean, he didn't have to go there.
Right, but that has nothing to do with whether or not...
So how can you say that there was provocation?
Okay.
Because you have to look at the actual circumstances.
Right. It seems to me you have to look at what happened. And the closest case that we have, I think, is Commonwealth versus Fortini, which is an appeals court decision that this court has cited since Fortini was decided. But it's not an SJC decision. In Fortini...
Has decided since something was decided, but not Fortini, because that's the case you're talking about.
You've cited Fortini...
since it was decided.
Since it was
Okay,
decided.
okay.
With, in Fortini, there's a history that took place just that night. And then the defendant goes downstairs to his porch with a rifle and waits. And one of the persons who was probably involved with what had gone on earlier in the night, which was drive-by shouting obscenities, things of that nature, comes up on the porch, sees the rifle in his hand, and lunges for him, according to Fortini. And the appeals court said that was reasonable provocation. That is very close to this case, except my facts are better, because my Anthony Clemente did not have his weapon out. He wasn't showing his weapon. He was told, someone or you or something about no one's getting out of here alive. And a person who had killed before stood up and went for his fanny pack, exactly where one would expect a gun to be. And two other members of the party picked up steak knives. You can look at the Commonwealth's closing argument.
If you're relying on his reputation and the history of what went on before, it seems as though it sort of pulls the rug out from under provocation, a sudden transport of passion, because the guy, he was anticipating this was certainly a possibility.
Right. Okay. Damian Clemente, on the evidence in this case, was living in total fear of these people. He was petrified of them.
But we're talking about Anthony.
No, we're talking about Damon.
I'm talking about my client. He's petrified of them. And he calls his father. He says, the father says that Damian tells him that the worst character of this whole group has been staring at him.
So why doesn't your client leave the restaurant?
Right. Well, that's why he's not entitled to an acquittal. He didn't think properly. People under the influence of extreme fear. By the way,
why does provocation apply to your client?
Because he was standing right there when the guy stood up and went for his fanny pack after saying, no one's getting out of here alive.
Your client is convicted on a joint enterprise theory.
Well, it's hard to tell what he's convicted of.
Well, I mean, he didn't do the shooting.
Well,
he did one of the shootings.
Yeah, one of his bullets was found in
the head of
Ramon or Robert.
Robert Luisi. And he's convicted of first-degree murder for that shooting. He's acquitted of the Roman Luisi murder. He's convicted of second-degree murder on the other two shootings. And he's found guilty of the lesser-included offense when properly charged on mitigation on the assault with intent to murder charge. The jury finds him guilty of only assault with intent to kill as to Richard Sorrow. When properly instructed that mitigation, all you have to have is a reasonable doubt about mitigation, this jury acquits him of assault with intent to murder.
Mr. Sheketoff, what is it you think we ought to do today?
With that fact?
No, with your client's case.
I think you should give him a new trial or reduce the conviction to manslaughter, give the Commonwealth that option. At least on this issue, if you agree with me on this issue. I don't think Fortini is distinguishable. I want to go to the defense of other instructions.
Just look at your time. You're almost out of time, sir.
Okay.
In fact, you are out of time. Thank you.
Good morning, Your Honors. My name is Rosemary Scapiccio. I represent Anthony Clemente in these matters. And I'd like to address the issues in my brief regarding the motion for new trial and the errors of the trial court in denying the motion for new trial.
I want to ask you first about the evidence of the conviction in California. First of all, it was the California shootings,
Yes.
the acquittal in California, I'm
Yes.
sorry. But isn't that hearsay and opinion evidence anyway? We've always said that you can't introduce somebody's acquittal or conviction because it's hearsay and opinion. And Adjutant didn't do away with the rules of evidence.
It didn't do away with the rules of evidence.
Except for
And
the one specific rule it did do away with. It didn't do away with the others.
They weren't looking to get into the issue that he was acquitted or convicted of that crime.
I thought your brief kept saying they wanted to get in the acquittal from California.
Well, the fact that he shot somebody. What happened in the California case and the evidence that was in the record at the motion for new trial, based on the entire California file, was that
wasn't there evidence that he did shoot this guy in
Yes,
California?
So
but
I
evidence
thought-
that was limited to reputation, not as evidence of first aggression. That's the problem with the evaluation of the Superior Court in this case. That evidence came in with a limited instruction by the judge saying you can only consider this evidence, A, if it was known to the defendants prior to trial, because this is reputation evidence, which there's nothing in the record to suggest
No,
Anthony...
it wasn't reputation evidence. It was evidence of a specific fact of a shooting.
The specific fact of a shooting, and what the limitation on that consideration was, it didn't go to who was the first aggressor. The judge didn't allow the jury to consider that evidence in terms of who the first aggressor was. And that's the issue with all of the evidence that the defendants repeatedly attempted to introduce to show who the first aggressor was.
Was this case tried before Adjutant?
It was tried before Adjutant. There was no, it was pending on direct appeal when Adjutant came down. We filed a motion for new trial based on Adjutant to include all of the issues that throughout the 22 volumes of this trial, defense counsel repeatedly attempted to get into specific instances of first aggression.
It appears that Adjutant applies to this case. I don't think that's an issue.
And so if Adjutant applies to this case, then it has to be retried. Because at every step of the way, when the defendants were trying to defend themselves, to prove the reasonableness of Anthony Clemente's actions in shooting 4 people during lunch, that it was reasonable based on the fact that these people were repeatedly first aggressors. And that's the evidence that never got...
That really doesn't sound like a first aggressor issue. I mean, it really sounds like the classic self-defense. When he made a move, I had a reasoned basis to believe he was going to shoot me. Therefore, I shot him. I mean, isn't that classic? What's that got to do with first aggressor?
Because the motivation for what the Commonwealth got to do with this case is pretend that these were just 4 people eating lunch who got blown away by my client. And that's simply not the state of the evidence.
You mean the jury got the impression that these 4 people who were sitting at the restaurant, some of whom died, were sort of like innocent bystanders?
Well, that's what the Commonwealth argued in their closing,
Yeah, but,
that
I
they
mean,
were innocent
was that the-
bystanders eating
But was that the
dinner.
flavor of these guys?
No, but the evidence that came in to suggest that they had a reputation in the community of violence was not able to be used to substantiate first aggression. And I disagree with you, Justice
Was
Cordy,
it
in
a
terms
question of first aggression? Was that a live issue at the trial?
It was a live issue in terms of the reasonableness of Mr. Clemente's actions.
And that doesn't sound like a
That's not a
first
That's not
aggressor.
the aggressor, though, is it?
But here's the problem. The way that this case has been evaluated by the Superior Court in this case, it takes everything and it compartmentalizes it into these are the police reports that weren't turned over because the subpoena was quashed in this case. This is the California case. This is over here the Ferlito grand jury stuff. As if each one of those were separate incidences that don't combine together to make up the mindset of what was going on here. If you take those and introduce them for the purposes of first aggression, you find within those police reports that on numerous occasions these individuals were the first aggressors.
But
They
don't
were the
you-
ones who, I'm sorry, Jim.
No, you finish.
They were the ones who started the aggression. They were the ones who pursued victims who weren't armed in this case. Those were the Boston police reports that weren't introduced.
Was that disputed in this case?
Yes.
That these guys, was it disputed that they had threatened the son?
No, not that they had threatened the son. I'm not suggesting that it was disputed that they had threatened the son. I think when Anthony Clemente testified, he indicated that they had threatened the son. But what the Commonwealth wants us to concentrate on is they were words alone. And that's simply not true when you take into consideration the entirety of this case. The entirety of this case is that, according to the Commonwealth, Damian Clemente was selling drugs in the North End. They wanted a piece of what he was selling. They wanted some tribute. He wouldn't give it to them. There were 3 separate meetings that went on between my client, Anthony Clemente, and Bobby Luisi, trying to straighten out the threats against Damian Clemente. In the first meeting, they said, fine, we'll let you handle it. In the second meeting, they said, fine, we'll let you handle it. By the time the third meeting came along, it was clear to Anthony Clemente that the Saros and the Luisis were going to kill his son. So clear, in fact.
But don't you have to focus on what's happening right there in the 99 in terms of first aggressor?
Absolutely.
And so, but is there any evidence of confusion as to who shot first? Or who
Not
shot?
who shot first, but who moved first. And that's the issue. It's not who shot first on first aggressor. It's who moved in that direction.
And so, but
So
the evidence
any
came in
movement-
about the, so you're saying because of the fanny pack.
Because of standing up in the statement, no one's getting out of here alive, and the move to the fanny pack, combined with 2 other people on that table standing up and grabbing steak knives. That's what happened.
Okay, would
in
you
the
answer
seconds
my
before these people
question, please?
shot.
Are you saying now you did not, or you aren't arguing that the acquittal about the California shootings should have come in?
No, I'm suggesting that that wasn't the focus of.
No, but your brief keeps arguing the acquittal should have come in, the acquittal should have come in, and the acquittal is hearsay and opinion. So what do you say about that?
Well, as far as the acquittal itself,
Yes.
the fact that the Roman Luisi was acquitted of murder in California,
Right.
it isn't the focus of my argument. It's not the focus of my argument.
Well, you wrote a very long brief and mentioned it many times, but maybe I misread it.
And perhaps not as clearly as I should have, Your Honor, but the focus of that was to be able to demonstrate under the adjutant now theory that this was a case where this individual pursued 2 unarmed kids.
Okay, so you don't want evidence of the acquittal to come in. You aren't arguing that that should have come in. Are you saying that?
I'm saying that it doesn't matter whether that comes in or not. The evidence that's important for the first aggression is the evidence that Roman pursued 2 unarmed kids and shot them with a gun he pulled from his fanny pack.
And your argument is that evidence of that came in, but it wasn't the judge didn't allow it to go to the jury on the issue of who was the first aggressor.
Yes.
I take it he did allow it to go in on the question of self-defense.
Yes, if this was the limitation with that, because it was reputation evidence. And the judge said over and over and over again, you don't get in specific facts because it's reputation evidence. And when the defendants went repeatedly to introduce specific facts of violence, the judge repeatedly said to them, it doesn't come in. This is reputation. That's
Excuse me,
not the
are
law.
you saying there was no evidence of specific acts of
I'm not
violence?
saying
I
that,
thought there
but
was
I'm
quite a
saying
bit.
The limitation that the judge put on the jury's consideration of that evidence is what requires reversal of this conviction. What the judge told the jury is, you can only consider the evidence of the reputation for the victim's violence. In this case, A, if it's known to the defendants, in this case, and in my case, there's no evidence that Anthony Clemente knows of these specific acts. The evidence that was presented by the defendants in this case is that Damian Clemente may have known of these specific facts, but not that Anthony Clemente knew about the specific facts. I'm talking about the Bruno beating. I'm talking about the incident that took place at the.
Did the Commonwealth dispute the fact that, or dispute the testimony that that the victims were in a restaurant and when that one of them said, no one's getting out of here alive, and he reached for the fanny pack and then picked up a steak knife?
No.
There was no dispute about that?
No.
So why is there a question about who was the first aggressor?
Why is there a question in this case as to who the first aggressor was? Because as far as the Commonwealth was concerned, they argued to the jury that these people were just innocent people eating lunch. And that's not true. They couldn't have argued that if the evidence of first aggression came in this case. And I would suggest that
They could have.
That
they were just sitting there eating lunch.
But
you can always argue that.
But as far as this case is concerned, the evidence that was considered by the jury of reputation was considered solely to what the defendants knew and only as to reputation. It wasn't allowed to be
But it was
considered
undisputed
for the
that
purpose.
it was undisputed that these guys had said nobody's getting out of here alive,
It
and
is
then they
disputed.
picked
If
up
you-
a steak knife
Did
and moved.
they say that that was a credibility, just what Justice Stevens, was the Commonwealth arguing, they didn't say that?
Credibility issue. If you look at the Commonwealth's brief, in the arguments against the adjutant application here, they say that there was an issue of first aggression. When they get to Mr. Sheketov's argument regarding the jury instructions, they say there was no issue. And so they're all over the board in terms of whether or not there was an issue of first aggression or not an issue of first aggression.
I have a question on another subject, and we're running out of time, so two questions, I guess. Anyway, two questions. On page 54 of your brief, you say, and I'm quoting, there was testimony that Luisi customarily wore that fanny pack to conceal a gun, unquote, and there's no record citation. Don't bother looking. Could you please supply a
Absolutely.
16L letter with the citation? Thank you. And the other thing is, how is the government acting with a similar motive at the grand jury in regard to Mr. Ferlito?
Mr. Ferlito, the evidence is that the night before this incident, Mr. Ferlito was in a cafe. Damian Clemente and Mr. Perez come in. There's an altercation there. In front of the grand jury, Ferlito says, I'm calling my uncle, and he's going to take care of this, basically. He's going to take care of Damian. That's the evidence that he testified in front of the grand jury. Commonwealth had a motive to get the truth out of him at that point. Whatever the version of the truth is, they knew that the incident had precipitated this murder. They knew that Ferlito was related to the victims in this case. There was no motive for them to do anything other than ask Ferlito what happened and get the truth. Now, when Ferlito takes the fifth and he can't...
Wait, what did Ferlito testify to at the grand jury?
Ferlito testified to the grand jury that he had an altercation with Damian. Shortly after the altercation, he was related to the victims in this case. He called Bobby Luisi, and he was told that Mr. Luisi would take care of Damian. That's what was in the grand jury. That never got before the jury because the trial judge indicated that once he took the fifth, that evidence doesn't get before the jury. Commonwealth now argues that somehow their right to confrontation was violated, and the reality of it is the Sixth Amendment right to confrontation is personal to a defendant. And doesn't necessarily apply to the Commonwealth to the extent that the Commonwealth wants it to apply. It's a personal right to the defendant. They don't have a right to confront witnesses in the same manner that defendants have a Sixth Amendment right to confront witnesses. So I would suggest that the argument that the Commonwealth couldn't cross-examine the witness that they put before the grand jury in this case makes no sense in light of their motivation at that time to get nothing but the truth from Mr. Ferlito.
Thank you, Ms. Scott.
Thank you.
May it please the court, my name is David McGowan, Assistant District Attorney for the Commonwealth here in this matter.
I have a couple of specific questions for you. When Anthony Clemente testified at trial to the statements that he made to the police, that he warned his son Damian to stop selling drugs in the North End and said he would do so, and the defendants argue that or the defendant argues there's no other evidence that Damian was a drug dealer. Was that statement, did the defendant request that that statement be limited to the father?
No, that's not my understanding. And to step back a brief moment, the statement I recall was Detective Keeler asked Anthony during one of their interviews, is this confrontation or is this tension due to some kind of turf war over drugs? And Anthony then responded, no, he told me months ago he was no longer involved in drugs. And that there was no request for any kind of limitation to my knowledge in the record, Your Honor.
All right, and is your argument that there'd be no substantial likelihood of a miscarriage of justice because it might have been a strategic error? I mean, a strategic intention to let it go?
Indeed. It might have been strategic and certainly is in some ways favorable to the defense in the sense that even if that was credited and a negative inference was drawn towards Damian, it gave it bolstered the argument of in serious fear of these known to be vicious individuals. So if there was, in fact, a drug conflict, it might bolster their case. In any event, the statement was he's no longer involved in drugs. So it clearly could have been strategic to either not draw attention to it or to just move
And
beyond.
another question, how do you justify the exclusion of Ferlito's grand jury testimony?
Certainly, Your Honor. At trial, when the judge determined he was not going to introduce that testimony, trial counsel for Anthony said, well, without that testimony, quote, we cannot put on the exact words of Roman and we cannot put on the exact words of Robert Luisi Sr. insofar as they concern what their plans were in terms of Damian Clemente and young Mr. Perez and what was said to Ferlito about those matters. That's at page 6 of volume 19. The only motive to introduce that evidence was to bring in rank hearsay into the trial. Where hearsay and evidentiary rules are relaxed at the grand jury, they aren't relaxed at trial. And so the only aim to get that evidence in, they wouldn't have in any event. In addition, that
But that, I thought your brief argued that you weren't, that it shouldn't come in because you didn't have a reasonable opportunity to cross-examine him.
well, that is also true. And in addition, as Your Honor pointed
But
out,
if the grand jury, if the Commonwealth is putting in the evidence, it never cross-examines anybody.
no,
But
it
can
doesn't.
ask whatever they want.
Yeah, they can do whatever they want.
Yeah,
They can-
so how do you justify that?
Well, in some
The
ways,
judge's ruling.
as my sister mentioned, that is to explore the truth. That's not always the case. It's to elicit testimony and sometimes get words on the record. In this,
But you aren't denied any opportunity. It's just like we always say about cross-examination. Just because you don't have the most effective cross-examination, as long as you have the opportunity, that suffices. And similarly, the Commonwealth has the opportunity at the grand jury to put in anything it wants.
that is, of course, the case. But even there's three things that need to be met for prior testimony to be
Unavailability. He's
admissible.
unavailable.
Unavailable, similar opportunity and motivation to cross, and then also substantially the same issues. Here, the issues were entirely different. At the time of this grand jury, the Commonwealth had a very strong idea as to what happened at the 99. They were exploring other avenues of what happened. So it's simply investigatory. It is not the same as trying to find guilt or innocence at trial. So we would argue that it's not the same motivation.
Let's assume for a moment that we agree with counsel that this evidence should have come in. What's the result of that?
Well, under the substantial risk of a miscarriage of justice standard, I would respond.
Substantial
Excuse
likelihood.
me. I would respond that evidence would solely
Why
be
is it
cumulative.
substantial likelihood? Did they object at trial? I forget there were so many issues.
Yes, it was a heavily
Yeah,
contested
so
issue
why would it
throughout.
be substantial
Prejudicial error,
likelihood?
isn't
Then it's a different standard.
Prejudicial error.
Excuse me, that is correct. It would be prejudicial error. In this case, the evidence elicited, if the grand jury was presented before the jury, it would have been cumulative of three witnesses. First, William Hutchinson, who was an eyewitness to the confrontation with Damian and Joseph Ferlito in the Cafe Victoria that evening.
Who? Hudson?
Hutchinson, I believe is his name.
Okay, all right.
And the second witness, Officer McDonald, who was right outside Cafe Victoria that evening and saw the mass exodus of all these individuals leaving that evening. And then Anthony also testified that Damian had come to him saying he had gotten in a beef with Robert Luisi's nephew, Joseph Ferlito.
Well, that establishes the fight. It
yeah.
doesn't establish the conversations with the victims.
That somebody's uncle is going to take care of this.
Of Damien.
That is true, but again, that would have been rank hearsay at trial.
All right.
So really, the Ferlito and Damian confrontation was properly before the jury.
Well, wait a minute. Did Ferlito make that statement at the grand jury that his uncle was going to take care of this?
That's not my recollection of the specific
Oh.
words. He did notify Roman and Robert, but that may have been the case.
Did the grand jury testimony indicate that Ferlito had personal knowledge of these statements?
These were phone calls that Ferlito made, right?
Yes.
Yeah.
Okay.
All right. So what do we do about this Acevedo error?
Yes, Your Honor.
Instruction.
The Acevedo error is only an issue if provocation instruction was warranted. In this case, clearly was not. In any event, it's only relevant to Anthony Clemente's conviction of the murder of Roman Luisi. There is no evidence alleged that Damian was provoked. There is no evidence that any of the other victims did anything that would warrant or substantiate a provocation instruction to begin
Well, they
with.
came at him with a
About
knife.
the knives.
That was only after Anthony had shot Roman in the chin.
Do we know that? Is the evidence clear as to the sequence of events?
According to Anthony's own testimony,
Well, what about when the shot that Damian fired? Did that come after the knives had been pulled out and they had approached him with the knives?
there's no evidence that they approached Damian ever. When Anthony stood up, he shot Roman Luisi in the chin. Then he says he turned and Sonny had stood up and he shot Sonny. And then as Robert reached for him, he shot Robert. And then he turned and then shot Roman twice more, once in the back and a better aimed shot to the head. Then he shot Ricky. After he shot Robert Luisi, he testified he then heard a muzzle blast coming from somewhere. He felt it. He couldn't tell where it was coming from. Presumably, the jury inferred that that was Damien's shot. So only after
I take it
Anthony
the ballistic evidence was that there were only 2 guns fired,
Correct.
a 9mm which Anthony had,
Yes.
and a .45 which Damien had.
Correct. Correct. And the other defendant, his gun was fully loaded outside, so there's no
Right.
evidence that was fired at all.
So you're saying the Acevedo error only applies to Anthony, and
Yeah.
only on that one shooting?
Yes. And further, that one shot may have been, the Commonwealth isn't conceding that, but even if that was sufficient provocation for that one shot, then Damien, after shooting Mr. Pelosi and after shooting Robert Luisi, then turns and sees Roman on the floor and then shoots him twice more, once in the back and then once in the head. That clearly isn't part of provocation. And the test for provocation is would a reasonable person have been sufficiently provoked into a heat of passion and in fact was provoked and did not cool off. In this case, even if this court determines that there was an objective provocation, the evidence of this case is that Anthony clearly was not subjectively provoked. He stated that when Roman's hands went down, he thought to himself, don't do it, don't make me kill you. And then when he was asked what his state of mind was, he said, it is simply to stay alive. And this court has said that when the
Don't you
calculus...
think "don't do it, don't make me kill you" is provocation? Doesn't that suggest provocation, that he thinks he's going to be shot?
No, that would suggest to me solely self-defense, that he's
That's
calm,
Anthony's
cool,
statement.
and he's rationally
Well, it
analyzing.
shows cooling off. It shows time, or in fact, cooling off. That's what
It's
you would
an express reflection, not an absence of reflection. And for this court has held where calculus of survival doesn't make provocation a live issue. Here, expressly, on Anthony's testimony, he says his sole purpose was to get those kids out of there alive. He went there knowing who his targets were. He walked into the restaurant not to shoot blindly. He prepared for and initiated this confrontation. It is solely about maybe self-defense, but this is not something where he was blinded by a passion and impulsive behavior. He was reflective, even to the point where when Roman stood up, he took a step back, put his hand out towards Roman, and said, it doesn't have to be this way. He was attempting to diffuse the situation, not something someone would do when they're struck and encountering a heat of passion. So clearly the evidence does not indicate, even if this court finds an objective person would have been provoked by Roman standing up and reaching to his fanny pack and some of the other members of the party holding steak knives, there clearly wasn't a subjective provocation.
So this is purely a self-defense case, and provocation, instruction on provocation wasn't necessary, so the fact that it was erroneous is of no harm.
Exactly, Your Honor. Turning to the defendant's claim under adjutant, here the argument is that they weren't able to introduce or let the jury consider prior acts of violence. And in this case, the testimony did come in a Roman shooting. Joseph Blazo testified that he had a conversation with Damien about how Roman Luisi killed 2 people in California and shot them in the back. And then also, Detective Ross in the Boston Police Department told the jury that
Yes,
Roman...
but the defendant's argument, as I understand it, is not that that evidence didn't come in, but that it didn't come in on first aggressor because the judge limited it to reputation only.
Well, limited to self-defense,
Well,
right? Or how did the judge limit this? Just get your take on it.
My understanding that it could only be used in how they deemed the credibility of the defense and that whether or not they were reasonably acting in self-defense and what they know about these individuals.
Right.
As Your Honor's pointed out, they knew an awful lot about these individuals, that he was charged of a 1992 double homicide in California, that he had shot 2 people in the back, but then also the rest of the party. Robert Luisi had a reputation of threatening people with knives, bats, and threats of arson.
And it was clear that the defendants were aware of that reputation?
Yes, Your Honor.
Okay.
That was the testimony.
Okay.
And officers testified to what the folks in the North End perceived these individuals to be like. So the reputations were established, but then more specific evidence were presented before the jury.
Did the Commonwealth dispute the fact that the Luisis were the first aggressors?
Not that the Commonwealth did not dispute that they stood up and were there, and they did not dispute the tension that brought everyone to the 99 to that incident. But in terms of the exact chronology of events at the 99, there wasn't much dispute that they stood up and had steak knives. There wasn't any dispute that Roman may have reached for his fanny pack. But that the evidence doesn't avail the
Did they
defendants.
dispute the fact that one of the Luisi said nobody's getting out of here alive?
They didn't dispute that. Even if he had said that, it doesn't change the analysis of how the jury can weigh this case. So that wasn't something that Commonwealth was forcefully trying to disregard and move on. They were encouraging the jury to look at the facts. There were no weapons found on the victims aside from the steak knives on the table. And there were bullets from the guns found on Damien, found in the head of Robert Luisi.
Did the Commonwealth oppose the defendant's request for instructions on self-defense?
No. And there was extensive instructions on self-defense in this case. The other specific acts that the jury did hear, in addition to the shooting, were Giacomo Cinconti was pulled from a car by Robert Luisi and then pistol whipped by Roman, that Robert Luisi threatened to pull Mr. Paul Bruno to beat him up and threatened arson, and that Blazo witnessed Robert pull Damien from a car and yell at him, and witnessed Ricky Saro threaten Damien. There were a number of specific instances that were put before the jury, so the jury was well aware of these individuals from specific acts and their reputation for violence in the community. Further, the grand jury testimony in terms of Alfred Sapochetti didn't exist at the time of trial. That testimony was given in November of 1997, and this trial concluded in May of 1997.
Can I ask you a question? I actually, I've got to go back and look at this more carefully. I'm somewhat confused about what this is. This undercover is an undercover police officer, or
In what respect, Your Honor?
this is Mr. Sapochetti.
There
Yes?
was a state police report that an interview with Mr. Sapochetti, where
Okay.
he outlined a number of different drug transactions around the
And
Commonwealth.
who is Mr. Sapochetti?
Just an individual, allegedly someone who was at the 99 earlier in the day but had left before this confrontation.
Okay, so at the time when he was at the 99, but may have left before the confrontation, he wasn't working for the federal government as an informant or anything of that sort.
That's not my understanding.
Okay. All right, so he was interviewed at some point.
And
Right.
those reports were not allowed in because they simply had no materiality or exculpatory evidence in them. Robert Luisi was mentioned as one of the person that there was a drug transaction with, but there's nothing to link the defendants in this case or anything to the 99.
So the defendants had the reports of the interview of Mr. Sapochetti, right?
I'm not sure if they had those at trial, but that was what they're alleging was improperly suppressed.
Oh, all right.
So
Okay, so the judge who heard the motion for a new trial considered whether or not that information, A, was within the possession of the prosecutor's office, and B, was exculpatory.
exactly right.
Or
I
material.
don't think the defendants had the reports regarding Mr. Sapochetti. That was
Then they were reviewing whether or not those were necessary.
Should have been
to
provided.
retrial.
Right.
Would have been there.
And then the other piece of this is Mr. Sapochetti's grand jury testimony,
Yes.
which didn't even exist until after the trial in this
Right.
case. And is there something of material nature in that grand jury testimony that relates to the guilt or innocence?
Not to guilt or innocence, no. There's evidence with regards to a drug transaction.
That took
Presumably
place
they-
at the 99,
Yes,
just before the shooting?
yes.
Okay.
And with, I
And was
believe
Mr.
the defense
Sapochetti...
contention was if there was drug dealings, then they were more likely to be armed.
I understand that argument.
Exactly.
Mr. Sapochetti, I take it, didn't testify that he witnessed the shooting
No.
in the grand jury.
And the drug transaction at the 99 just before the shooting was between whom? That, according to
Allegedly between Sapochetti and Roman Luisi.
and this would provide evidence of that Luisi was armed.
Because he was...
I thought we said drug dealers aren't necessarily armed.
That is correct, Your Honor. Indeed.
Okay.
Are there any other
Anything
issues
else,
or-
counsel?
Your Honors, have any questions?
All right, thank you, counsel.
Thank you.
Thank you.